Welcome to the concluding lecture on the case studies relating to evergreening of patent. In the last three lectures, we discussed two important cases. One very recent case, not relating to a pharma patent, but relating to a telecommunication and biotechnology patent. At least the telecommunication patent will come under the category of standard essential patent, getting it pretty close to the pharma patent. The other one is on biotechnology. And the next thing that we discussed about is the Lipitor case. Athar was chatting. Now, this was during the time frame 2010. Now, we are going to see one very earlier, most successful evergreening. And this was done relating to the molecule Omaprazole. Omaprazole is an active ingredient used for the treatment of peptic ulcer, gastroesophageal reflux disease, prevention of gastrointestinal bleeding, what is popularly known as heartburns. Now, let us understand this molecule. This molecule was invented in Europe in 1979. And the inventor company is Astra of Sweden. And this was approved for clinical use in 1988. Please remember the time gap between the date of innovation and the date of regulatory approval. Almost about a period of 9 years actually. So, 8 years out of the 20 years patent monopoly is gone. And this is one of the reasons why the research-driven pharma multinational corporations had been demanding a patent term extension. And nowadays, there is a lot of countries who have decided to give a single term extension actually. 5 years usually it is given, but it is still not given in countries like India actually. Now in 1979 is the date of invention and 1988 is the date of regulatory approval. This is again one of the important blockbuster drugs for AstraZeneca. And it is in the list of WHO essential drugs. It's an essential drug, means it's a life-saving drug actually. And during 2001, the prescriptions for this Omaprazole, which was sold originally under the brand name Losec, and subsequently it was changed into pre-Losec actually, because there was some confusion about an existing drug earlier. Originally it was Losec and subsequently it was changed into pre-Losec actually. And most importantly, it is a over-the-counter drug. A consumer can just go to the shop and buy it actually without having to give any prescriptions for it actually. This much about the chemical history and the regulatory history of the Omaprazole. Now, how do the evergreening come into picture? 1988 is the date of regulatory approval. 1999 is the expiry of the basic molecule, Omaprazole patent actually. But then, according to a US FDA study, by 2010, 40 patents have been made in and around the Omaprazole. Some of it relate to delayed release mechanism. Some of it relate to improved process for making the omeprazole. Some of it relate to enantiomer. We discussed about this enantiomer in the last lecture also. It is the same thing, but it is different for various reasons actually, and I gave you the illustration also. And this enantiomer patent was taken by AstraZeneca itself. And this enantiomer patent, they started making it in the name of Nexium. So, in other words, the AstraZeneca tried it wonderfully well actually, evergreening. We discussed in the Lipitor that the Pfizer's effort was fairly successful in United States, not so successful in Europe. In India, they lost a case, and therefore they decided that discretion is better part of valor. And both the companies, decided to settle the dispute. And Ranbaxy paid some money and withdrew some drugs and got license to produce it and co-market and abbreviated new drug application in many areas along with United States of America. I told you that this dispute between Pfizer and Ranbaxy got settled within 3 years actually. Okay. And one more thing I must always tell you is that whenever two companies file a case and arrive at a compromise, and if these companies are market leaders in their respective spheres, for example, Ranbaxy was a market leader in the introduction of generic drug products. Pfizer was a market leader in the introduction of research drug products. And both of them, for whatever reason, filed cases against each other. And these cases are fought in different jurisdictions. That way, Lipitor litigation is the delight for patent litigators actually. It was litigated in several places and, both parties arrived at a settlement. That means, many people, particularly lawyers, are fond of saying that a bad compromise is better than a good decree. Even in India, when there was a case between Cipla and Eli Lilly, regarding a cancer drug, they fought it hard in the Delhi High Court, and both of them didn't really get much. The case was taken to the Supreme Court. When the Supreme Court was about to consider that the patent monopoly was getting over, and both the parties thought that they need not wash their respective dirty linens in public actually. So they arrive at a compromise. So what I am trying to tell you here is that this should normally come under the operation of the Competition Commission. Whether the compromise itself is an anti-competitive practice, because very often there will be a challenge to the validity of the patent and that challenge will be withdrawn. That is another issue, and that's a side story which we must consider elaborately in a competition law course. Now let me tell you about this. I told you evergreening was attempted very successfully by Astra. What they did is they came up with a lot of improvement patent. First improvement was relating to delayed release mechanism. Second improvement was relating to better processes. Third incremental innovation was relating to combination product. And the fourth type of innovation is enantiomer. And this enantiomer, omeprazole metamorphosed into rabeprazole, esomeprazole, lansoprazole, pantoprazole, tentoprazole. Okay, there have been, different, and if you had looked at it, if you look at the survey again, 59% were in composition, 41% in manufacturing process, 28 type of patent, use patent or prescription patent, which is available only in United States, Israel and all that, not in India, 22% method patent, 1% drug combinations. So the point I am trying to impress upon here is that the AstraZeneca had In 2001, a sales of about $5.7 billion. As soon as the patent expired, they came up with an enantiomer patent for which the patent was taken somewhere in the year 2000. Regulatory approval were granted to enantiomer pretty soon actually. So, they were able to market this enantiomer under the new brand name Nexium, and they were able to ensure that I told you that in 56 American million prescriptions were there for this product. 70% of them, the company was able to divert it actually, which is a very big deal. Okay. Now, let me also tell you that not only AstraZeneca made money out of their omeprazole patent by evergreening. In fact, an Indian company, Dr. Reddy Laboratories, growth. See, I want you to appreciate that during 1979 up to 2005, there was no effective product patent regime in India, only process patent regime. Because of this, many of the drug companies did not even apply for patent protection in India because, number one, they don't grant patent protection for product. Number two, under the earlier law, the truncated term, 5 years from the date of grant, 7 years from the date of application, whichever is less. 3, all the patents came up with an endorsement that licenses of right. All these things are not there anymore in the Indian patent law because of Indian membership to WTO TRIPS agreement. So, in India, Omaze was one product which contributed significantly for the growth of the Dr. Reddy Laboratories. Omaprazole was not only a blockbuster product for AstraZeneca, but Omaze was a blockbuster trademark product for Reddy Lab. The Reddy Lab was actually, AstraZeneca was making this, Astra was making the product in India, Losec, okay? But the Omaprazole was so cheap in India, sold under the brand name Omaze, that Astra had to abandon the sale of the Losec in India because they were simply not in a position to compete with Reddy Laboratory. So the point I am trying to tell you here is that evergreening, meaning an attempt of the innovator company to extend the product life cycle of a technology, is legitimate. After all, when there is a facility available to the patent owners, naturally the patent owners have a right to avail that. 2, many of these companies who come up with blockbuster drugs, okay, are afraid of falling the patent cliff. If there is going to be a generic substitute in the place of a patented medicine, the patentee company is going to suffer a big dent in their sale. So they will naturally try to do that. So now I want you to appreciate that the compulsory licensing is a very important tool where the abuse of the patent monopoly can be curtailed. After all, we must not forget that people like Mrs. Gandhi, a charismatic Indian leader, went to WHO and thundered that life-saving medicines must be available free to the entire humanity without regard for the profit and product life cycle management of a molecule, etc., etc. That part of it we will check up in our next module, which will focus exclusively on the impact of the COVID pandemic on the public health care scenario. Thank you. I hope you found the presentation on evergreening of patent interesting. This case study, Omaprazole case study, dates back to 1980. At that time, India did not have a product patent regime. We have been having a product patent regime beginning from 2005. Now, the pandemic had brought about a lot of misery on most of the world. But companies like Pfizer, Moderna, Bharat Biotech, to some extent AstraZeneca and Serum Institute of India have made tons of money. Pharma industry itself has had a big fillip after the pandemic. It is in this context the issue of evergreening of patent becomes very important for developing societies that face a lot of resource constraints as well as public healthcare delivery problems. Now, India had made the biggest experiment, boldest experiment to have a different regime for pharmaceutical products that will facilitate better diffusion of technology relating to healthcare inventions and at the same time preserve the incentive that is available under the patent system to the inventors of new drug. This is in Chapter 16 and 17 of the Indian Patent Act. Experiments, Chapter 16 and 17 of the Indian Patent Act tries to bring about a balance between these competing interests. We have tried to consider the impact of the Indian reforms on patent law in a course stretching over about 4 hours, presented in 4 modules and 16 lectures. We think the course will promote literacy amongst law students, pharma professional, healthcare activists. If you like, please, we are providing a discounted link to the enrollment of the course. Please check it out. Thank you.